Hello, I'm Dana Sparks, broker with Maximum One Greater Atlanta Realtors. And today's contract tip has to do with a law that was signed by Governor Deal to go into effect July 1, 2015. Earlier this week, I went to a Cobb Association of Realtors broker dinner, and one of the speakers there was Keith Hatcher, the Chief Public Policy Officer for the Georgia Association of Realtors. In his presentation, he discussed a law that will affect all real estate agents in the state of Georgia regarding interacting with clients and advising them on contracts. So, as you know or should know from license law 43-40-25.1, completion of certain forms, not practice of law, contents of certain forms. That's the title. This law has already been in effect for us as real estate agents since 2014. And basically what the law on the Georgia books said prior to this session of our state legislature is it shall be lawful for licensees to complete listing or sales contracts or leases whose forms, shall be lawful for licensees to complete listing or sales contracts or leases whose form has been prepared by legal counsel, and such conduct shall not constitute the unauthorized practice of law. In completing a lease or a written offer to buy, sell, lease, rent, or exchange real property, a licensee shall include a description of the property involved, a method of payment, any special stipulations or addenda the offer requires, and such dates as may be necessary to determine whether the parties have acted timely in meeting their responsibilities under the lease, offer, or contract. That's all it stated. So basically, what the law that has been on the books for Georgia stated is that you as a real estate agent, you can fill out a form prepared by an attorney and you can write some special stipulations. That was all that it said. So the law, House Bill 153 that Governor Deal just signed into law and goes into effect July 1, now adds a little more authority to you as a real estate agent with respect to the real estate contract and interacting with your client. So what the law says, well, it will be law in 2 days, says it is an amendment to amend Article 3 of Chapter 19 of Title 15 of the Official Code of Georgia Annotated relating to the regulation of the practice of law. Let me read you what the change is going into effect. A broker, associate broker, or salesperson licensed pursuant to Chapter 40 of Title 43, which is license law, a seller of real property or the employee of a seller of real property or an employee of a property management company engaged in the leasing or management of commercial or multifamily properties may, number one, provide information and advice to their principals, clients, and customers in matters involving the listing, management, sale, purchase, exchange, renting, lease, option, and other conveyance of any real estate or the improvements thereon. That's the change. And then prepare special stipulations to forms that were prepared by an attorney in connection with the listing, sale, purchase, exchange, renting, lease, or option of any other real estate or improvement thereupon. Provide the legal forms prepared by an attorney to their principals, clients, and customers, and complete legal instruments prepared by an attorney for their principals, clients, and customers. So the subtle change that went into effect is going into effect states that as a real estate agent, you may provide information and advice to your principal, client, and customer, basically as long as it pertains to the law that you are held to, which is license law. So just wanted to bring you up to date regarding the changes in our Georgia legislature pertaining to your real estate license. As always, be extremely careful if it is a legal situation that is above and beyond license law and the laws to which you are held. Strongly suggest that you do have the client or customer consult with an attorney. Thank you again. I'm Dana Sparks, Broker with maximum one Greater Atlanta Realtors.